India's first National Pharma Online Symposium. So, this session is going to be indeed a very insightful one because the speaker that we have today, Dr. Tanya Ralli, who is PhD from Jamia Hamdard and a gold medalist from NIPER, Mohali, and she's completed her bachelor's from DIPSAR, authored more than 8 books and published more than 25 plus papers. So, ma'am has qualified a plethora of examination like CSIR NET for the life sciences, UGC, JG Bills, GATE, and many more. Ma'am is also a second ranker in her BPharm, so she has been a consistently topper. And to be honest, we had an expert speakers right from the day one, that is the Saturday, Mr. Aditya Jindal, Dr. Raman, Dr. Farah. Unfortunately, because of some medical emergencies, Dr. Tanya's session has been rescheduled for today. And Mr. Byomnath Chaube, Dr. Akash, and Mr. Shams from IHMR Bangalore, Associate Professor. Mr. Asim Saifi, the Head of Department in HEOR. Mr. Pavam Devkam, who is a Junior Research Associate at NIPER Mohali. And Dr. Ankita Su. So today we have Tanya ma'am, who will be delivering an insightful session on and giving you the answer of who are you. So probably you'll have an insight about what exactly is the patent, what exactly is the basic to advanced. Almost everything will be covered in simple language by IPR, a prospective career, as the main topic for today's session. So, handing over the session to you, Tanya ma'am. Thank you so much for accepting the invitation for today's session.
Thank you, Payam, for giving me this opportunity, and also thank you for the introduction. So, like, I just want everyone, please give some answers to me. Okay? So, let's not make it a boring session, and we will just indulge in some like interactions. So, can anyone tell me what is IPR? What is IPR? Anyone?
Intellectual property rights.
Yeah, it's intellectual property right. And can you give a brief introduction about this? But what is intellectual property right? Why it is intellectual? Why it is property? Why it is right?
Rights that we have on our ideas or something that intellectually we have of our own.
Yeah.
So that
Yes, correct, Drashya. Very good. So anything that we have created from our mind, that anything that we have created from our mind, that can be covered into IPR, intellectual property right. Similar to any property, like any property that we own, like a car or a property or a place or a home, all those properties are immovable. Like these properties we can touch. They are tangible. जिनको हम touch कर सकते हैं. But intellectual property, it is a property that we have created from our mind. But we are getting right for that. What are the rights that we are getting? For that, we can get different kind of rights. Like there are mainly 7 type of IPR. If I show you what are different kind of IPR, just a minute. Can you see my screen? Is my screen is visible? Visible है मेरी screen? Is my screen is visible?
Yes ma'am, yes ma'am.
ठीक है, अगर कोई भी doubt हो तो बीच में मुझे रोक देना, because I cannot see the chat box. So just let me stop. ठीक है, तो अब हम लोग डिस्कस करते हैं what are IPR, what are different IPR. So IPR is they are the legal protection that we have obtained from the creation of our mind. The major type of IPR include patent. First one is patent. Anything that we have produced, like any product that we have produced or any process that we have produced, we can get a patent for that. So patent is a type of IPR. Trademark is a type of IPR. Copyright is a type of IPR. Industrial design is a type of IPR. Geographical indication is a type of IPR. All these are different type of IPR. We are getting right for these. So what are the differences between these IPRs? In patent, if there is any technological advancement, any technology that you have improved, maybe you have made a new product or you have made an old product, it with the help of a new process. So any technological advancement or economic significance, like we are producing it at a very cheaper rate. There is a method of preparation of one compound. By that method, I can produce that drug for 1 lakh rupees, 1 lakh rupees per gram. But I have prepared a method that gives equal yield, and that is producing that compound at a price of just 1000 rupees a gram. So it would be economically significant. So any technological advancement or economic significance or both, कुछ भी अगर होता है, but apply किस पर होगा? That would be applied to either a new product or a new process. Like I have one medicine which is penicillin. So if I have made a penicillin with the help of new process, or I have a dosage form tablet, and I am preparing it using a different method, and I am producing a dosage form by different method, and that process is either technologically advanced or it is showing economic significance or both, then I can obtain the patent for that. If suppose I have a brand name, I have a logo, I want to register that brand name, then that I can protect under trademark. If suppose I have made a new computer program, so by per se, computer programs are not patentable. If you want to get a patent of any computer program, you have to attach it with some hardware. Softwares are not patentable. Computer programs are software. Software is anything that we cannot like touch. हम उसको touch नहीं कर सकते. That's a programming language. I am programming it. So softwares are not patentable. But if I use that software and combine it with some hardware, then that can be patentable. But if you want to get your software as a IPR, you can register it under copyright, not under patent. Any artistic work, like you have made a beautiful scenery, you have written a very interesting poem, or you have created a drama, all those artistic and literary work would come under copyright. Any aesthetic appearance, you have made something whose appearance is very beautiful and his appearance is novel, that you can register under industrial design. So it should appear, aesthetic appearance should be there for industrial design. Any if you want to protect a product of a specific geographical location, like sarees of Banaras, Banarasi sarees, Assam ki tea, all those would be protected under geographical indication. Then plant varieties, by default, plants or animals, we cannot, any microorganism, we cannot get patent for them because they are already in the environment. We are not doing any invention. They would come under discovery. So any plant or any animal, the extract, the method I am using from extracting a specific constituent from a plant, that can be patentable. But a plant cannot be patentable because it's a discovery. It's not innovation. So if I want to protect any plant variety, that would come under Plant Varieties Act. So remember it. But if suppose you have discovered one microorganism which is already there in environment, you have just discovered that microorganism won't be patentable. But if you had prepared a recombinant microbe in your lab, that can be patentable, that you can patentable. Then layout design, that would be your integrated circuit. So mainly in pharma domain, because there are many innovations going on, more and more drugs are invented, so the patent field is very much emerging. So what are the different career pathways that you can opt for? So first, there are few pathways in which we usually have a doubt. One is patent analyst and one is patent agent. What is the difference between these two? Patent analyst is the person who is analyzing the patent. What I am doing, I want to invent something and I want to check whether whatever I am inventing, whatever I am trying to invent is already there in public domain or not. So anything which is already there in the public domain before the date on which you are filing. Suppose I am filing a patent on 10th of June 2026. So anything, anywhere present in the whole world in public domain would come under my prior art. If if I found anything similar or exactly same as what I have applied for, then my application won't be granted. So for that, there are various patent analysts and patent associates who basically what they will do. Yeah, IP consultant. IP consultant is a broad domain that they will consult you related to patents, trademark, copyright. But if there is a specific person who is like helping you to understand that whether your work is novel or not novel, whether your work is falling under the criteria of patentability or not, if that person is dealing only with patent, then that person would be a patent analyst. And IP consultant would give you consultation on any like patent, copyright, trademark. So basically, what does the patent analyst do? They will search for different prior art. They will search for the existing prior art which is related to your work. So थोड़ा सा मैं आपको बताती हूँ एक्चुअल डेमोन्स्ट्रेशन से कि कैसे सर्चिंग होती है. So for patent searching, there are n number of domains that you have to search. You can search for the patents. You have to search for patents.
Hello, ma'am.
Yes.
Sorry for interruption, ma'am. Can you please aside the pop-up, that pop-up screen?
Just
Yeah.
a minute. Now is it fine?
Yes, ma'am. Yes, ma'am.
Okay. So for patent searching, like what you will do, if suppose you are planning for any work, then what you will do, you will search various search engines. You have to search for both the papers, research papers, review papers, and also the patents. You have to search everything. So your work should not be present. It should not be present in patents as well as in any research papers, in any thesis. It should not be present anywhere. So for searching the patent analysts are trained to do that. I will share some basic techniques that they use, but there are n number of websites and there are n number of techniques by which they can simplify their work. First, what they will do, they will understand your work. They will find out the major keywords. That what are the keywords? Like suppose if you are doing any work on suppose acyclovir, you have done something on acyclovir and you are targeting suppose HIV or any such thing. So they will first figure out what all are the keywords that we need to search. So first they will jot down all the keywords which are related to your invention. So how they will search? What we want to do, we don't need to miss anything. So what we will do, we can use some operators. There are three major common operators that I can use, and or not. And means if I'm saying acyclovir and HIV, so it will include all the papers or all the patents that contain both these words. I can search these words in either description or title that I will show you later. But and as a like search and like this operator is used whenever this is used, your paper, if that paper contain both things, then only that paper would be included. So and would basically narrow down your search. So if you have used the word and, then you will definitely get less number of paper. If you have searched only acyclovir, then suppose you are getting 1 lakh papers. If you are searching only HIV, you are getting 2 lakh papers. If you are searching HIV and acyclovir, definitely the paper would be less than 1 lakh. It would be something around 70,000-80,000. So AND operator is used for narrowing down your search. But the use of AND must be used properly, because this don't narrow down your search in such a way that you miss out something. So one operator is AND. Other operators is OR. This or this. If the paper contains either this word or that word, then that paper would be included. Like usually we use these words for synonyms. जैसे हम synonyms use करते हैं ना, suppose कुछ papers होते हैं जिसमें specialization लिखा है, S लिखा है, किसी में specialization में Z लिखा है, तो स्पेलिंग में चेंजेस होते हैं, मीनिंग सेम होता है बट वो यूरोपियन इंग्लिश और यूएस इंग्लिश में डिफरेंस है, तो वहां आप और सर्च इंजन यूज कर सकते हो. कोई डिजीज जैसे कि नाफिल्ड, नॉन अल्कोहलिक फैटी लिवर डिजीज, या फिर पूरा नॉन अल्कोहलिक फैटी लिवर डिजीज, कोई लिखेगा नाफिल्ड, कोई लिखेगा नॉन अल्कोहलिक फैटी लिवर डिजीज, तो आप और सर्च इंजन यूज कर दो, दिस और दिस. Not if you want anything which should not be included in your paper, then in your search, then you would add not. And there are some wild cards that you can use. What these wild cards are? One is this question mark and another is this star. So if you put one question mark, then it include that one letter would be included. Like specialization. In this question mark, this means that this place would contain any letter because there is specialization LISATION and also ZATION. So if I put a question mark, then it will include either S, Z, P, Y, anything. It will include that. If suppose you know two words, you are confused with two letters, then you can put two question marks. You can put a question mark in first or a third position. Depending upon your keyword list, you have to make the use of these question mark, that what all I can use and or not question mark, so that मुझे minimum to minimum syntax लिखना पड़े. Syntax is anything that I'm giving to the keyword search. Then there is a possibility of this form, this star, asterisk mark. So if you have right form and then a star, so anything after form would be included, like formulation, forming, formation. Or if suppose you have written star and then a word, so anything before that word, all those words would be included. So these two wildcard you can use in your keyword searching to give a better syntax. So आप इधर इन ऑपरेटर्स का यूज कर सकते हो और इनका यूज कर सकते हो. जितना ज्यादा प्रैक्टिस करोगे ना, उतना ही ज्यादा आप सीखोगे. So this is how you can refine your keyword searching. There are different search engines. Like there are for research paper or review paper, you search for you go to Science Direct, you go to PubMed. अलग-अलग आपके सर्च इंजन आप वहां पे जाते हो. ऐसे ही पेटेंट की सर्चिंग के लिए इंडिया का जो पेटेंट का डेटाबेस है, दैट इज इनपास. देन हमारा यूएस का पेटेंट का डेटाबेस है यूएसपीटीओ, यूनाइटेड स्टेट पेटेंट एंड ट्रेडमार्क ऑफिस. देन आपका जो वाइपो, वर्ल्ड इंटेलेक्चुअल प्रॉपर्टी ऑर्गेनाइजेशन का डेटाबेस है, दैट इज पेटेंट स्कोप. देन यूरोपियन का जो है वो है एस्केप नेट. देन आपको गूगल पेटेंट तो पता ही होगा. तो ये हम अलग अलग सर्च इंजन यूज कर सकते हैं अपनी सर्चिंग के लिए. मैं जरा आपको एक दो एग्जांपल दिखाती हूँ. आई होप माय स्क्रीन इज क्लियर नाउ. माय स्क्रीन इज विजिबल?
Yes, ma'am.
ठीक है. सो सपोज आई हैव सर्च फॉर पेटेंट स्कोप. दिस इज माय पेटेंट स्कोप. दिस इज अ वाइपो पेटेंट डेटाबेस. Here, this is field, that where you want to search. You want to search your keyword in text, full text, or just you want to search in claim, or just you want search in name of the person, publication date. Suppose I have done full text. Suppose I would write acyclovir, acyclovir. Okay, I will search for it. Let's see what would be the result. So you can see there are 62,468 results would appear. So these are different results that you can see. Just scroll down and go to the next page. You will see all the results. 6,247, 62,000 results आए. अब अगर मैं next करूं, मैं कर दूं acyclovir and HIV. So you can see they were they were 62,000 and now your results had got down to 29,328. So depending upon your keyword search, you can do and, or, not, question mark. You will make a proper syntax that is called as a proper syntax. You will like first prepare a proper syntax and then you will search in different your databases. Then like if I give you the example of Google patent, this is a Google database. जैसे Google Scholar होता है रिव्यू पेपर रिसर्च पेपर का, ऐसे ही Google पेटेंट के अंदर सिर्फ और सिर्फ आपके पेटेंट्स आते हैं. सो गूगल पेटेंट में आई हैव गॉन टू ब्रेस्ट कैंसर. यहाँ पे ये साइन आता है कि पेंसिल जैसा, इसको हम टिक करते हैं तो वी कैन लाइक do any advanced search, like we can put a priority dates. I can change those dates. I can change the language, like what language I want, either English or German or whatever language that I want. It will search. So suppose it is showing more than 1 lakh results. So you will make a proper keyword and you will search. So first step is creating the keywords, then searching all the search engines, and then we will like see all the, like we can download also. We can, right now it's not downloading. हम इसको download करके भी हमारे पास एक Excel फाइल में आ जाता है. Then हम पहले हम टाइटल पढ़ के हम स्क्रीनिंग करते हैं that depending upon these title, these papers are not at all required. Then whatever is required, we will study the abstract for those papers. So by abstract reading, we also like cancel out some papers that these are not required, like these are not similar to our research. Then the remaining we have to search, like patent analysts have to search, have to read all the papers, and they have to analyze that whether the conditions of patentability, there are 3 conditions of patentability. One is novelty, second is inventive step, and third is industrial applicability. इंडस्ट्रियल एप्लीकेबिलिटी को सर्च नहीं किया जाता, वो तो आपको ये देखना होता है कि क्या ये चीज इंडस्ट्रियली एप्लीकेबल होगी कि नहीं होगी. सो दैट इज कंप्लीटली डिफरेंट, उसको नहीं सर्च किया जाता. हम पहले 2 क्राइटेरिया को सर्च करते हैं, नोवेल्टी एंड इन्वेंटिव स्टेप को, और उस बेसिस पर वी विल फिगर आउट दैट वेदर whatever we are claiming is similar or not. So these are like a bunch of small work that I have shown you. इस तरीके से पेटेंट एनालिस्ट काम करते हैं. So if you have a lot of interest in reading new things, reading different patents, reading different innovative work, then you can opt this field. So you must have the curiosity of reading and analyzing things. Then only you can like go into that field, because उसी field में जाओ जहाँ पर interest आता है. So I hope patent analysts का आप लोगों को समझ आ गया होगा. Clear है सबको? Is
Yes,
this
ma'am.
clear to everyone?
Yes, ma'am.
ठीक है. अच्छा, आप कोई मेरे को बताएगा, मैंने आपको 2 कंडीशंस बताई. वन इज novelty and another one is inventive step. What is the difference between these two? What is the difference between these two? Anyone?
Ma'am, novelty is newness to the innovation. That is newness.
ठीक है.
It
And
cannot
what is inventive step?
inventive step. Inventive step. I don't have
Suppose,
idea.
चलो मैं बताती हूँ. सपोज एक रिसर्च थी, पेनिसिलिन के बारे में ऑलरेडी रिसर्च पेपर्स में है, एस्पिरिन के बारे में ऑलरेडी रिसर्च पेपर्स में है. What I have done, I have combined those two and I have made some formulation. Suppose a combination is given in neither of the paper nor in any of the patent database, then that means it is new, because that combination is new, that is not written in any database. But what that combination is giving me the result, are these results obvious to the person skilled in the art? Obvious to the person skilled in the art का meaning है कि जो पर्सन उसी फील्ड का है, क्या उसके लिए जो मैंने रिजल्ट बता रही हूँ क्या वो ऑब्वियस है कि ऑब्वियसली ऐसा होता है. लाइक मैं पैरासिटामोल 600 mg यूज कर रही हूँ और मैं एस्पिरिन 200 mg यूज कर रही हूँ. जितना पैरासिटामोल सपोज मेरा फीवर उतार रहा है, एस्पिरिन जो है वो सपोज मेरा एंटी क्लॉटिंग की तरह यूज कर रही हूँ, और जितना इफेक्ट मेरे को दोनों चीजों को इंडिविजुअल यूज करने पे मिलता था, कॉम्बिनेशन भी उतनी ही डोज पे देने पे सेम इफेक्ट ही मिल रहा है, बस जो अलग अलग दो चीजें थी वो आपको एक दवाई में खाने से मिल गई। सो क्या ये न्यू है? बिल्कुल न्यू है, किसी ने इनका कॉम्बिनेशन नहीं बनाया, अगर नहीं बना होगा तो, बट दिस इज ऑब्वियस टू एनी पर्सन कि अगर अलग अलग इतना इफेक्ट दे रहा है तो मिलके तो देगा ही देगा ना। सो दिस वुड your the criteria of novelty would be justified, but the novelty of inventive won't be justified. But suppose whenever you are giving paracetamol and aspirin and you have like combined those two, and what you are seeing that when you have given 650 mg of paracetamol and you have given 200 mg of aspirin, the same effect is produced at 200 mg of paracetamol and just 50 mg of aspirin. Then is it obvious? Then is it obvious or not obvious? Matlab there is something, interaction is going on, something novel is going on, then it would be non-obvious. Clear है? So in novelty का criteria तो बहुत सारे patents qualify कर लेते हैं, but inventive step के criteria में बहुत सारे patents fail भी होते हैं. So ये criteria को judge करना, check करना, this is the work of patent analyst. देन एक आता है हमारा काम जो होता है पेटेंट एजेंट का. अब पेटेंट एजेंट का एक एग्जामिनेशन होता है नॉर्मली. वैसे तो बिना एग्जाम दिए भी यू कैन बिकम अ पेटेंट एजेंट, बट यू आर नॉट अ पेटेंट एजेंट, यू कैन ड्राफ्ट. पेटेंट एजेंट वुड draft your patent in such a manner that it would be easily understandable and all the forms, everything would be properly, you have submitted them. यू कैन सी लाइक आपको पता होगा, आप कोई भी एग्जाम का फॉर्म भरते हो और अगर आप फॉर्म में कोई भी एक छोटी सी गलती कर दो, लाइक आप अगर फोटोज डालना भूल जाओ, तो क्या आपका फॉर्म रिजेक्ट हो जाएगा? क्या आपका फॉर्म टेक्निकल ग्राउंड पे रिजेक्ट नहीं हुआ? दैट इज जस्ट द टेक्निकल ग्राउंड होते हैं वो ग्राउंड्स कि आपका पेटेंट ही गलत है, उसको मिलना ही नहीं चाहिए. दूसरा होता है क्लरिकल जो काम है, उसके बेसिस पर आपका फॉर्म रिजेक्ट हो गया. तो सेम पेटेंट फाइलिंग के लिए भी बहुत सारे डॉक्यूमेंट देने होते हैं, आप कोई फॉर्म भूल गए, तो ये काम नॉर्मली लोग पेटेंट एजेंट से कराते हैं कि आप प्रॉपर फॉर्म बनाओ, सारे फॉर्म फिल करवाओ, देन आप हमारे पेटेंट को ड्राफ्ट करो, प्रॉपरली ड्राफ्ट करो, उसकी लैंग्वेज ठीक रखो. डेटा मैं ही उनको बताऊंगी कि मेरे पेटेंट का क्या है, बट दे विल मेक इट इन द फॉर्म that need to be submitted. Like if I show you one example of a patent, this is one example of Indian granted patent. So there are various forms, like there are 37 forms in Patent Act, and you have to submit this form number 2. Form number 1 is basic application form, and form number 2 is that basically contain all the details of your invention. So in first page, it is written title of the invention. So title is saying method and apparatus for safe path prediction of miners using hazard aware graph attention. Normally it is said that title should be less than 15 words, से छोटा छोटा होना चाहिए, और उसके आगे you should mention that is it a method, is it a apparatus, what is it? So it is a method and apparatus, or if you are including only the method, then method for this. So how to write the title of your invention. Then the applicant details are there, and after that the major part comes is the field of invention. Field of invention usually 4 to 5 lines में होती है about that what your invention is relating to. So the present invention relate to this machine intelligence, machine learning, this is this. So maximum 2 to 3 points में आपको field of invention देनी है, that what I am talking about. Then what I have made, what are the background in the past, what all things are there related to my research and where are they lagging. तो वो होता है बैकग्राउंड ऑफ इन्वेंशन में कि क्या क्या चीजें ऑलरेडी मेरी इन्वेंशन से रिलेटेड बैकग्राउंड में क्या है, कि इस फील्ड में ऐसा ऐसा काम हो रखा है, थोड़ा थोड़ा बेसिक में हम बताते हैं बैकग्राउंड में. फील्ड ऑफ इन्वेंशन में वी टॉक अबाउट आर इन्वेंशन, बैकग्राउंड ऑफ इन्वेंशन में वी टॉक अबाउट द पास्ट, द प्रायर आर. Then we talk about the summary of invention, that what our invention has done. So that is a summary. Then individual, all the prior art description that you think that this patent discloses something like this, but my is different. So what all are the patent you think are similar to your work, but they are not exactly same to your work? You have to give those all the data in prior art description. Then the technical advancement over prior art, because I have told you that either there should be a technical advancement or there should be an economic significance. Then what advancement your work has done over the prior art? Then whether your work is industrial applicability, is there any utility? You have to mention that. Then summary of your invention you have already listed earlier. Then brief description and your एक होता है brief description जिसके अंदर basically if you have made some drawings or figures, you have to give the caption for those in the brief description. In brief description only the caption जो हम papers में caption लिखते हैं ना, captions of figures and tables would be given. So brief details of tables हो गए. Then detailed description के अंदर पूरा का पूरा डिटेल आपकी इन्वेंशन के बारे में कि आप क्या क्या चीजें हैं. And the most important heart and soul of the patent would be the claim. तो क्लेम को लिखना बहुत प्रॉपरली आना चाहिए कि क्या इसके अंदर हम क्लेम कर रहे हैं. Anything which is covered in claim would be covered. If your patent is granted, so your patent would be granted for only these claims. So anyone who has made some changes in the claim, then that person is not वो आपका काम चुरा नहीं रहा. So anything that is covered in claim is the most important part. So claim में हम क्या लिखते हैं? A method for predicting this, which comprise of this, and then the method as claimed in claim 1, it further contains. So mainly जब हम claim बनाते हैं, there are two type of claim. One is dependent, one is independent. नाम से ही समझ आ रहा है, डिपेंडेंट इज समथिंग जो किसी पे डिपेंड होता है, इंडिपेंडेंट इज समथिंग जो किसी पे डिपेंड नहीं होता. मैं अगर अभी स्कूल में हूँ, कॉलेज में हूँ, जब तक मैं पढ़ाई कर रही हूँ, आई एम डिपेंडेंट ऑन माई पेरेंट्स. सो दैट वुड बी अ डिपेंडेंट क्लेम जो किसी चीज पे डिपेंड कर रहा है. बट जब मैं खुद से सपोज अर्निंग शुरू कर दूंगी, तो मैं सपोज अगर इंडिपेंडेंट हूँ, तो आई एम इंडिपेंडेंट. तो यहाँ पर वो एक मेथड के बारे में बता रहा है, इससे वो किसी चीज को रिलेट नहीं कर रहा. सो दिस इज अ इंडिपेंडेंट क्लेम. यू कैन रीड दिस क्लेम इंडिपेंडेंटली, बट एज यू कैन सी द क्लेम नंबर 2, फॉर अंडरस्टैंडिंग दिस क्लेम you have to first understand the claim 1. So the method as claimed in claim 1, it contains this. So जब तक आपको claim 1 नहीं पता, आप claim 2 को नहीं समझ सकते. So this 2 is a dependent claim and it is dependent upon claim 1. Similarly, अगला, the method as claimed in claim 1. So it is also a dependent claim and it is dependent on claim 1. अगर suppose इसमें लिखा होता the method as claimed in claim 2, so this would be a dependent, but it would be dependent on claim 2. So normally जब भी हम लोग पेटेंट की फीस वगैरह की बात करते हैं, तो एक स्टैंडर्ड फीस दी जाती है कि ये फीस है अगर आपका पेटेंट जो कंप्लीट पेटेंट है, if it is less than 30 pages and it contain less than or equal to 10 claims, per page increase they will charge a cost. And per claim increase after 10 pages, they will like charge you for that claim, increase claim. So normally लोग try करते हैं कि 10 claims के अंदर हो जाए, but जितने ज्यादा claims होंगे उनकी payment देनी पड़ती है. और claims.
हेलो मैम.
हाँ जी बताइए.
मैम क्लेम री-एक्सप्लेन कर दीजिए, नहीं समझ में आया.
Claims के type री-एक्सप्लेन करूँ?
यस मैम.
देखो वैसे तो ना देयर आर मेनी टाइप ऑफ क्लेम्स लाइक ऑम्बिगस क्लेम, जैप्सन क्लेम, वो सब हमें डिस्कस नहीं करना, बट अ बेसिक ऑफ डिपेंडेंट एंड इंडिपेंडेंट क्लेम. प्रजापति, आपका नाम क्या है? व्हाट इज योर नेम? आई एम नॉट एबल टू गेट योर नेम. नितेश. ठीक है. सो नितेश, इफ सपोज आई एम टेलिंग यू देयर इज अ कॉन्सेप्ट ऑफ डिपेंडेंट वेरिएबल, इंडिपेंडेंट वेरिएबल. वेरिएबल इज एनीथिंग दैट वेरी. If that variable depends on anything, then it would be dependent. And if that is not dependent on anything, then it would be independent. So if I have told you this is claim number 7. This claim is stating the method as claimed in claim 1, wherein the super node invading the system model collective minor behavior assessment given है. So क्या claim 7 को समझने के लिए पहले आपको claim 1 को समझना पड़ेगा? Yes or no, नीलेश?
Yes, ma'am.
So ये 7 number claim is dependent upon claim 1. So it is a dependent claim. But if I check this claim number 1, a method for predicting safe path of minor in this, it comprises of this. So what normally I do, we usually first make a independent claim, which contain the major parts of your whatever like process if you have made. So it will divide your process into steps. So for explaining this step, I will make a second claim. For explaining this step, I would make a third claim. For explaining this step, I would make a fourth claim. So this is an independent claim, because for understanding it, I don't need to read any other thing. But for understanding this, as stated in claim 1, so I have to first read claim 1, I have to understand this claim 1, then only I would able to understand claim 2. So that means this claim 2 is dependent upon claim 1. And usually, खुद सोच के बताओ, आपका जब आप claim लिखना शुरू करोगे, तो it should start with an independent claim. First claim should be independent or dependent?
Independent, ma'am.
First claim should always be independent. उसके बाद आप ऐसा कर सकते हो, दो तीन claims आपने dependent बना दिए, फिर आपने next एक और claim बना दिए जिसको आपने independent करा. जैसे आपने अपने मेथड को सपोज 4 पार्ट में डिवाइड करा, अगर आपको क्लेम का नंबर बढ़ाना है तो 2 को एक में लिख दो, फिर उन 2 को इंडिविजुअली समझाओ. और इवन ऐसा भी बनाए जाते हैं क्लेम्स, द मेथड एज क्लेम्ड इन क्लेम 1 एंड क्लेम 2, दैट इज कॉल्ड एज अ डिपेंडेंट क्लेम व्हिच इज डिपेंडिंग अपॉन 2 मोर क्लेम. सो ये आप टर्मिनोलॉजीज देखो, वेयर इन these are the words, these are some things that we need to understand properly while drafting the claim. This word comprising, there are 2 words, one is comprising, one is consisting. Can anyone tell me the difference between these two? What is the difference between comprising and consisting? कोई बता सकता है? नॉर्मली अपनी फॉर्मुलेशन में यूज करते हैं, क्या कोई बता सकता है कंप्राइजिंग एंड कंसिस्टिंग में क्या डिफरेंस होता है? बताओ. बताओ, एनीवन? नहीं आता तो मैं बताती हूँ, बताओ. देखो, जो कंप्राइजिंग वर्ड यूज होता है ना, वो एक ब्रॉड क्लेम को दिखाता है. दिस इज अ ब्रॉड क्लेम, फ्लेक्सिबल क्लेम है. मैंने कंप्राइजिंग में जो जो चीजें लिखी है ना, इसके अलावा कोई और चीज अगर किसी इंसान ने फॉर्मुलेशन में डाल दी तो उस बंदे का क्लेम मतलब कवर होगा. कंप्राइजिंग इज ब्रॉड होता है, वो फ्लेक्सिबल है. इसके अलावा भी कोई चीज ऐड हुई तो वो हमारे क्लेम के अंदर कवर हो सकती है. बट जहां पर भी आपने कंसिस्टिंग ऑफ लिख दिया, कंसिस्टिंग का मतलब होता है बस यही सब चीजें मेरी फॉर्मुलेशन में है, अगर किसी और ने इसके अलावा कोई और चीज डाली तो उसका इन्वेंशन डिफरेंट हो जाएगी मेरे से. सो कंप्राइजिंग और कंसिस्टिंग बहुत सोच समझ के यूज करना पड़ता है. कंप्राइजिंग ब्रॉड है, लेकिन कंसिस्टिंग इतना नैरो है ना, उसमें आप कोई और चीज, और किसी और इंसान ने फ्लेवर बढ़ाने के लिए भी कोई और चीज यूज कर दी ना, तो आप ये नहीं बोल सकते कि इसने तो सेम मेरे जैसी इन्वेंशन यूज करी है, क्योंकि आपने कंसिस्ट वर्ड यूज करा था. तो इसके अलावा कोई और चीज किसी और ने ऐड करी तो वो आपकी इन्वेंशन को इन्फ्रिंज नहीं कर रहा. तो ये टर्मिनोलॉजीज होती है जिनको समझना बहुत जरूरी होता है. सो कंसिस्टिंग नॉर्मली इज अ नैरो एंड, और ये एग्जॉस्टिव होता है कि बस यही सब मेरी फॉर्मुलेशन में है, इसके अलावा और कुछ नहीं डाला. तो नॉर्मली आपको जितने भी क्लेम्स मिलेंगे वहां कंप्राइजिंग यूज होता है. तो ये वर्ड्स का यूज करना, ये सब चीजें हम सीखते हैं और यही सारा काम करते हैं पेटेंट एजेंट. So these are two major fields जो मेनली मतलब जिसके बारे में हम डिस्कस करते हैं. देन पेटेंट एनालिस्ट हो गया. पेटेंट एजेंट, आप अपने आप को पेटेंट एजेंट तभी कह सकते हो इफ यू हैव क्लियर द गवर्नमेंट पेटेंट एजेंट एग्जामिनेशन. देन एक टर्म आती है पेटेंट अटॉर्नी. पेटेंट एजेंट क्या करेगा? पेटेंट एनालिस्ट वुड सर्च फॉर patents, he would search for patents. Then patent agent would draft for patent. You can become both a patent agent as well as patent analyst. Then what you will do, if suppose what does patent agent do? Patent agent would either draft the patents, he would submit your patent, and if suppose there is some hearing, that patent agent can appear before the controller, but you cannot appear before controller. So patent agent, registered patent agent can appear before controller. But if suppose any case related to patent goes to the court, like high court, supreme court, lower courts, so there the person has to appear before a judge. So patent agent cannot appear before a judge. He can only appear before judge if he has a LLB degree. So anyone who has LLB degree plus patent agent, he can draft the patent, he can appear before the controller, he can also appear before the judges. But the patent attorney should always has LLB. Patent agent or patent analyst की field में जाने के लिए there is no requirement for LLB, but for patent attorney you require LLB. Then you can go into teaching and research field in IPR domain. You can become an IP consultant, means you can consult related to all the IPR domains like trademark, copyrights. You can open your own entrepreneurs like firm. So I have made you understand what are the different roles of patent agent, patent analyst. Then these are the roles of patent agents and attorney, drafting of patent, responding to examination reports, opposition hearings, filing karna. There are many companies who are hiring patent agents as well as patent analysts. So these are some companies which are basically pharma related companies. These are non-pharma because patent can be filed in any technological advancement. Technology can come into any engineering sector also. So these Samsung, LG, Intel, जितने भी आप देखते हो Apple का कोई processors है, सब चीजें सब patented होती हैं. So ये companies non-pharma companies है, इनके अंदर आप नहीं जा सकते, but you can go into pharma companies. Then you can also go to IPR consultancy firms. They are just dealing with IPR consultancy, like patent analyst related work. These are Cleverate. You have learned about Cleverate, Graby, and IPR Mint Law. These are different companies that you can go. एंड लीडिंग, आपको पता होगा आपके कॉलेजेस में आते ई वैल्यू सर्व बहुत कॉमन है जो आईपीआर डोमेन में स्टूडेंट्स को हायर करती है, एग्री भी करती है. सो ऑल दिस यू कैन गो इनटू. एंड व्हाट आर द बेसिक स्किल्स दैट दे रिक्वायर? So basically they want you that if you have basic knowledge of patent laws, databases, if you have either if you are a fresher but you don't have the basic knowledge about law but you have good writing skill, drafting skill, you have good interpretation skills, then they can hire you. Getting into IPR domain through a college placement is easy. It's definitely easy. But if you want to go into IPR domain, like by default, not from a campus placement, just you want to get into company, you are mailing them. So probably they require you some kind of experience. Either you have some knowledge about patent, or you are a patent agent itself. You have qualified the examination, or there is some referral. Then थोड़ा सा difficult होता है entry level पे. अगर आपका थोड़ा सा होता है कि आपको कुछ knowledge, extra knowledge होनी चाहिए, तभी वो fresher hire करते हैं. So basic skills required है. Educational pathway तो आप कुछ भी देख सकते हो. बस LLB is required for patent attorney, not for patent agent and patent analyst. And this is all about what I need to say. कैसे स्टार्ट कर सकते हो अपना करियर? पेटेंट लॉ के बारे में पढ़ो, बेसिक्स के बारे में, क्या क्या डेटाबेसेस होते हैं, कैसे सर्चिंग करते हैं, कैसे ड्राफ्टिंग करते हैं. धीरे धीरे करके चीजें सीखोगे तो इजी होगा इस फील्ड में जाना. But सबसे most important है for getting into this field, you should have the good reading skills. मतलब एटलीस्ट अच्छी रीडिंग स्किल्स होना बहुत जरूरी है. बिकॉज पेटेंट को बनाने के लिए, पेटेंट को सर्च करने के लिए आपको पेटेंट को समझना जरूरी है. So अगर पढ़ना अच्छा लगता है then it is a good field for you. And also work from home opportunity है जो normally लोग ढूंढते हैं शुरू में, might not be a work from home opportunity but with experience it's a work from home job. Anything that you want to ask? Hello? Any doubt? Anyone? नहीं है तो नहीं बोल दो, फिर वाइंड अप करते हैं सेशन को. और ये तो मैंने बहुत छोटी छोटी चीजें बताई हैं, ऐसी बहुत सारी चीजें हैं जो हमें मतलब याद ध्यान रखनी पड़ती है. बट फर्स्ट यू हैव टू डिसाइड दैट व्हाट पाथवे यू वांट टू गो, क्योंकि मल्टीपल चीजों में जाने का सोचोगे तो फिर वो पॉसिबल नहीं रह पाता. करो लेकिन अच्छे से इन डेप्थ पढ़ो. मैम इफ आई वांट टू गिव पेटेंट एजेंट एग्जामिनेशन from where we can study for the same. देखो पेटेंट एजेंट एग्जामिनेशन के लिए मेनली क्या होता है, द सिलेबस इज वेरी डिफरेंट. सिलेबस में आपको पेटेंट लॉ, डिजाइन लॉ पढ़ना पड़ता है, आपको एक्ट्स के बारे में पढ़ना पड़ता है. So for a patent agent, what you have to know that एक तो you should be a science graduate. Any science graduate can give the patent agent examination. Minimum age is 21 years. There is no maximum age for patent agent. Then these are the criteria, and you must be from the national. You must be from India. India citizen होने चाहिए. That is not related to pharma subject. That is completely different. For that, you have to study the laws. That what are the different laws, patent laws. So for that, I also give training for that. I also teach, but there are many platforms that you can search. बहुत सारे. Yeah. Yeah, last year. Like every year there's the exam. There is a exam every year in January, first week or second week. Like the exam, the form is usually comes in June to July. So इस बार का भी एग्जाम आने वाला है, मतलब फॉर्म आने वाला है. So if you want to study, so पहले आपको डिसाइड करना पड़ेगा कि हाँ आपको पढ़ना है, because there should be a dedicated study for 3-4 months. तो डिफिकल्ट नहीं है बट इतना भी इजी नहीं है क्रैक करना. अगर मेहनत करोगे तो हर चीज पॉसिबल है, बट डिसाइड करना पड़ेगा कि आपको करना है कि नहीं करना. बट यू मस्ट बी ग्रेजुएट, योर degree should be completed, or you are in the third year of, you are in the final year of your graduation, then only you can give the examination. Thank you. Thank you. Mhm. Well, thank you. ये एक्चुअली मेरी कल बहुत ज्यादा तबीयत खराब थी, तो आई थॉट कि मैं बोल ही नहीं पाऊंगी, तो इट्स बेटर कि अगर रीशेड्यूल हो जाए तो. हम्म. वो बहुत अच्छी इमर्जिंग डोमेन है, बिकॉज आप लोगों को भी पता है कितना ज्यादा मतलब गवर्नमेंट भी प्रोवोक कर रही है कि इन्वेंशंस करो, इन्वेंशंस करो, इन्वेंशंस करो. सो ये बहुत अच्छी फील्ड आने वाली है, और सबसे बेस्ट अपॉर्चुनिटी है वर्क फ्रॉम होम. कहीं पर भी हो यू कैन डू योर वर्क. हाँ. और अभी क्या है, अभी इतना ज्यादा एक्सप्लोर्ड डोमेन नहीं है जितना, मतलब इतना ज्यादा नहीं है, तो थोड़ी अपॉर्चुनिटीज ज्यादा है. हाँ लोग मतलब इतने सारे लोग तो मुझे ऐसे मिलते हैं जो मुझे कॉल करते हैं पेटेंट एजेंट का पूछने के लिए, एंड दे वर लाइक 30-40 years ऑफ एज, एंड उन्होंने पहली बार सुना इस एग्जाम के बारे में. सो बेटर आप जितना अर्ली क्रैक करो. हाँ नितेश बताओ, आपने हैंड रेस करा है, कुछ डाउट है?
मैम मैम सिलेबस कौन सा प्रेफर करेंगे?
किस चीज का?
पेटेंट का जो
पेटेंट
एग्जामिनेशन की बात कर रही हैं उसका।
हाँ, उसके अंदर ना बेयर एक्ट्स होते हैं यूनिवर्सल के, मतलब आपके ना जैसे लॉज होते हैं, एलएलबी में लॉज पढ़ते हैं ना, तो पेटेंट का और डिजाइन का ये दो के लॉज होते हैं. सो आफ्टर बिकमिंग अ पेटेंट एजेंट यू कैन फाइल बोथ पेटेंट्स एंड डिजाइन्स. जैसे डिजाइन्स की रजिस्ट्रेशन भी आप कर सकते हो, तो वो लॉज को पढ़ना होता है. एंड एग्जाम की अगर मैं बात करूँ तो देयर आर टू पेपर्स, पेपर 1 एंड पेपर 2, दोनों सेम डे पर होते हैं. एक ऑब्जेक्टिव पेपर होता है, एक सब्जेक्टिव पेपर होता है, एंड 2 आवर का बीच में गैप होता है. एंड दोनों 100 मार्क्स के एग्जाम होते हैं. दोनों में आपको मिनिमम 50 मार्क्स क्वालिफाइंग चाहिए होते हैं. अगर आप दोनों में 50 मार्क्स लाते हो देन यू विल कॉल्ड फॉर इंटरव्यू विच इज फॉर 50 मार्क्स. तो टोटल 250 मार्क्स हो गए, एंड anyone scoring above 150 marks would become a patent agent. So there are no number of seats, it's just the criteria. Any, like if 500 students qualify the criteria, 500 would get patent agent certificate. If 100 is qualifying, then 100 would become.
ओके थैंक यू मैम, वेल
What is the name of the exam for being an IPA? It's ये आपकी CGPDTM करके है, मतलब जो इंडियन पेटेंट ऑफिस है वो श्रुति इसको कंडक्ट करती है. इंडियन पेटेंट ऑफिस आईपीओ की वेबसाइट पे आप देख सकते हो, वो कंडक्ट करती है आपके एग्जाम को. और पेटेंट एजेंट एग्जामिनेशन आप लिखना, गवर्नमेंट पेटेंट एजेंट एग्जामिनेशन, आपको उसके बारे में मिल जाएगा. ठीक है श्रुति?
Excuse me, ma'am.
हाँ जी, हाँ जी.
Ma'am, is there a difference between a patent agent and a patent attorney?
Yeah, I have told you now that patent attorney would be any person with LLB degree. So any person, like if there is a case, like suppose if anyone has if anyone has used your invention and you want to sue him. So if you are going to the controller is the person, he is a controller general of patent design and trademark. If you are going to that person for a hearing or any sort of things, then the patent agent can appear before that person. But if you want to take him to the court, either a district court or a high court or a law, then you must have a LLB degree. That person would be called as a patent attorney. There is no examination for patent attorney. You just have a knowledge of patent and you are a LLB holder.
Okay, ma'am. Thank you.
आईपी देखो, मैंने वही आपको बताया कि देखो ये कंपनीज ना, कुछ कंपनीज आती हैं कैंपस प्लेसमेंट के लिए, एंड कैंपस प्लेसमेंट में दे यूजुअली टेक हायर फ्रेशर्स. वो ले लेते हैं जिसको बेसिक नॉलेज भी होता है, वो उनको हायर करते हैं.